My name is Chip Parker. I am a foreclosure defense attorney from Jacksonville, Florida. My firm handles more than 300 actively defended foreclosures throughout the state of Florida. And today I'm going to talk to you about the significance of the lost note count that most certainly appears in your foreclosure complaint. Clients often come to me, they've read on the internet, they've read maybe one of the articles I've written that, hey, there's a lost note count. That means they can't find my note. And so I'm going to win my foreclosure. And the answer is it's not quite that simple. But it is significant that a lost note count is alleged by the plaintiff. And as a matter of fact, I'm starting to see more often that plaintiffs are not alleging a lost note count. Now, why would a plaintiff allege a lost note count? Well, the Florida statutes have a provision that if the originator or a legal transferee of a promissory note loses that note, then Florida law allows for that entity to come into court to prove that a copy of the note should be substituted for the original. Because see, you always need the original note in order to foreclose on a home. You need to have physical possession of the note. Now, if a mortgage company says we've lost the note, chances are that is a mortgage company that has purchased the note from the originator. And the truth of the matter is that the way the financial industry has worked for so long is that they never actually physically transfer the original note from the originator to the purchaser, the subsequent mortgage company, which is in many cases actually not a mortgage company at all, but a securitized trust. So let's say that there is a lost note count. The significance of that, in my eyes, is that the plaintiff hasn't yet taken physical possession of the note. If the plaintiff hasn't taken physical possession of the note, then the plaintiff doesn't own the note, because one of the requirements to own a promissory note is to physically accept the note. And if you haven't done that, you don't own it. If you don't own the note at the time that the foreclosure was filed, then you don't have the right to foreclose on the home. Now, what happens if later on, because this is exactly what happens in a foreclosure case, the plaintiff will then file the original note? Well, what's happened is that the mortgage company or the plaintiff, which is sometimes a securitized trust, will track down the note and then file it with the court. Well, if the mortgage company subsequently tracks down the note, it is most likely that it is the first time it's taken possession of the note. And if that's the first time it's taken possession of the note, then that means at the time the foreclosure was initiated, it didn't own the note. And you can't retroactively go back in time and say, well, I have the note now, so 2 months ago I had the right to foreclose. It doesn't work like that. You have to have physical possession of the note prior to initiating a foreclosure. A lot of judges get it, and a lot of judges say, well, that's a technicality. Well, it gets a little bit deeper and a little more complicated than that, because most of these mortgages today are held by securitized trust. Now, a securitized trust is governed by something called a pooling and servicing agreement. That pooling and servicing agreement is essentially the instruction manual for the trust. Now, in that pooling and servicing agreement, there is an instruction that the trustee of that trust must take actual physical possession of all of the promissory notes by a specific date. And if the trustee doesn't take physical possession by that specific date, then I don't think the trustee can ever take physical possession, because it's not allowed in the pooling and servicing agreement. This fact is so important. The actual physical delivery of these notes is so important that every single trustee of every single securitized trust executes a a certification which is on file with the Securities and Exchange Commission that states something to the effect of, I, Joe Smith, Senior Vice President of Deutsche Bank, as trustee for the WAMU Trust 2007-2, hereby certifies that I have taken actual physical possession of each promissory note which has been endorsed in blank or endorsed specifically to the trust. Now, the reason for the requirement of that certification, I've already explained to you, that everybody knows that a negotiable instrument must be physically transferred from the originator to the new owner in order to complete the transfer of ownership. It's not good enough to send an email from the originator to the trustee saying, I hereby transfer all of my right, title, and interest in that promissory note from me to you. It doesn't work that way. So, when you have a foreclosure, and that foreclosure contains a count 2, the first thing that you should do is go to the back and look at the promissory note which is attached to the complaint. Now, you'll find one of 3 things. You'll find no promissory note at all attached to the complaint. You'll find a copy of a promissory note with no endorsement attached to the complaint, and that endorsement would say pay to the order of blank. Or number 3, you'll find a blank endorsement attached. You'll find a note with a blank endorsement attached to the complaint. Now, in any case, you should see a foreclosure defense attorney to discuss whether or not you have a good defense case against your mortgage company. If you do, you may be able to shift enough leverage from the bank to you to force them to negotiate a modification of your loan. And that's really what this is all about. It's about shifting leverage. The reason why your modification isn't going through right now is you have zero leverage. These mortgage companies aren't incentivized to modify your mortgage, and the only way they're going to become incentivized to modify your mortgage is if they recognize they'll never be able to take the property. That's what a good foreclosure defense attorney does. He convinces, or she convinces, the bank, the mortgage company, the trustee, that you will never be able to take this property, which is exactly what I do. And as a result, we've had good success in tying up foreclosures and shifting that leverage. And I am often getting calls from trustees offering to do things like reduce balances, reduce interest rates, re-amortize loans, and that sort of thing. But it only comes through leverage because these guys don't want to voluntarily do anything. Forget the Obama plans, forget mortgage modifications outside the context of litigation, because they just don't work. Even when they offer something, it's never truly a fair deal. My name is Chip Parker. Thank you for listening to me. If you would like to contact me, look at the email on the bottom of this video. It's parker@jackslawcenter.com. Thank you.